this way.
May I please do, my lords? 2 points. One, just to confirm that I gave you the correct reference to my Lord Justice Popplewell's point about judgment of order. I've checked the commentary myself. It is the commentary upon Section 16 of the Senior Courts Act, which, as we know from Mr Thompson's helpful intervention, is the very essence of the approach.
Yes, I looked at it for myself over the adjournment because you'd given me the reference. Thank you.
Thank you. Well, that's the first point. The second point is that I checked the written closing submissions, where I thought that the passage that I last alluded to might be, or that was on the stick that the post-it that I was handed. And it's the very paragraph I actually read over to the court. So it's 2279.5 on page, supplementary bundle, page 1339. Those are the only 2 points I wanted to add. Thank you very much indeed.
Thank you.
My lady, I then turn finally to the first 2 grounds in the respondent's notice. If I could just take you to the respondent's notice just to identify what those grounds are first of all. It's in the core bundle, page 174, part of divider 8.
If you would just give me a moment to put this back. $174.
That's right, my lady. So these apply in relation to ground 1 of the appeal, and they seek to uphold the judge's declaration that the leasing terminated on alternative grounds. So if we're wrong on ground 1, we obviously say we're not wrong on ground 1, but if we are, we say that the leasing terminated in any event by virtue of these alternative grounds. And as you can see, there's 2 of them. The first is in effect a point based on the effect of the sales, and then the second is a point based on the Cape Town Convention as incorporated into English law. Now, what I was proposing to do is just very briefly explain the context. Secondly, I'll deal with the procedural objection, which is taken, which was the focus of my learned friend's submission. And then, subject to the court, I'll make my submissions on the substance of the 2 grounds. So the factual context is very straightforward in our submission. And it's simply that the title to the aircraft was transferred from the lessors to 4 entities referred to as the trustee owners by way of sales that took place in January 2022. And the facts in relation to that you can find set out in the judge's judgment at page 94 of the core bundle, paragraphs 58 and 59. And he records there the sales that took place. And as you can see, they broadly fall into 2 categories. So the Neo aircraft was sold pursuant to a strict foreclosure sale under the Uniform Commercial Code of New York. And the Neo lessors consented to and were part of that sale. And then the position in relation to the CEO aircraft was different. Those were sold to the CEO trustee owners following a public auction process. But what matters for these purposes is that the sales took place in January 2022. The other point that matters is that those sales were registered on the International Registry, which is a Cape Town Convention institution, as we'll see. Just to give you the references for that, if you go to Core Bundle 261, at paragraph 66.5 of the particulars of claim, we pleaded that the sales of the aircraft were registered on the International Registry. And if you go to 305, within the defence, at subparagraph 6, towards the top of the page, that was admitted. So the judge doesn't, in fact, deal with that detail in the judgment, but it was an admitted point. So as we'll come to, essential facts are the sales took place as per the judgment, those paragraphs which I showed you, and the sales were registered at the time in the international registry. And the question which arises on the respondent's notice is, well, what was the effect of the transfer of title in January 2022 on VietJet's rights as sublessor, if those rights were still subsisting at that time because the termination notices had not been effective? And we say, in that scenario, the leasing of the aircraft was terminated in any event, either because VietJet did not have the benefit of any interest under the leasing capable of binding a third-party purchaser, and that's respondent's notice ground 1, or pursuant to the Cape Town Convention, as implemented by the regulations, the trustee owners acquired their interest in the aircraft free of any interest of VietJet, and that's respondent's notice ground 2. Now, as the court will have seen, VietJet has not engaged with those submissions at all. Instead, it's raised a procedural objection to the court considering the respondent's notice, which we say is thoroughly misconceived, but I'll deal with that first, given that's obviously the logically prior point. Now, the essence of VietJet's position is that it says we're not able to advance these points at all by way of respondent's notice because they are grounds of cross-appeal for which no permission has been sought or granted. And in our submission, that is simply wrong. If I could start first with the law, and it's helpful to pick this up from the Brace Yourself case, which my learned friend took you to, and that you will find in the authorities bundle behind divider 22 at page 550. And if you go first of all, please, to paragraph 17 to 18 on page 556. Paragraph 17 and 18 helpfully set out the relevant provisions, firstly of the CPR rule 52.13, but then also in paragraph 18 of the practice direction. And you can see in paragraph 18, the paragraph 8 of the practice direction says a respondent who seeks to appeal against any part of the order made by the court below must file an appeal notice. The respondent who seeks a variation of the order of the lower court must file an appeal notice and must obtain permission to appeal. And that's then to be contrasted with 3. A respondent who seeks to contend that the order of the court below should be upheld for reasons other than those given by that court must file a respondent's notice. So that's essentially the framework which you get from the rules and the practice direction. Now, in terms of the relevant principles, the Court of Appeal dealt with that on page 561, paragraphs 30 through to 32. And then you'll see 30A, I think that touches on the point that was discussed during my letter from Mr. Lissak's submissions. Paragraph 31 is of principal relevance to my submissions. So, subparagraph A, CPR Rule 52.13 and paragraph 8 of the practice direction draw a clear distinction between a respondent seeking to challenge or vary the order on the one hand and a respondent seeking to uphold it on different grounds on the other. The latter, which requires no permission, is a recognition of the special position of a respondent simply defending the decision in his or her favour. And then C, I think B we can skip over, that's not, I think, relevant for our purposes. C, the general rule that what matters for these purposes is the court order and whether there's challenge to it will not be enforced so strictly as to ignore the reality of what a respondent is trying to do. So the effect of a particular order or disposal is to be determined as a matter of substance and not merely of form. And in our submission, that's an important point, which we will come back to, because in my submission, to the extent there's any force at all in my friend Lord Wolfson's point, it's a point which is entirely based on the form of the order, which happened to be made by the judge in this case, rather than on the substance. Now, it's helpful, I think, in that context, then, just to turn to the order that was made by the judge. And you will find that in the core bundle at divider 4, and in particular at page 60. Now, the relevant provision of the order for these purposes is paragraph 1. Now, just to set the context for that, the primary relief sought by my client at trial was a declaration that the leasing of the aircraft had terminated. We sought that declaration on 2 bases. Firstly, contractual termination pursuant to the effect of the termination notices, which we said had been validly served. And secondly, the effect of the sales themselves, which in any event took place in January 2022. Now, what the judge did is he agreed with our first case. And as I'll show you in a moment, on that basis, he didn't see the need to go on and deal with the second case. And he says that expressly in the judgment. So he found our first case was right. The leasing had terminated. And that was on the basis the termination notices were valid. And on that footing, he made the declaration in paragraph 1. Now, that declaration, as drafted, in fact, has really 2 parts to it, because the operative part of the order is the first phrase. The defendant's right to lease each of the aircraft was terminated. That's the declaration of termination which we were seeking. The rest of that paragraph, perhaps slightly unusually, sets out his reasoning as to why that was the position, and effectively that encapsulates his acceptance of our first case, that it terminated because of the effect of the termination notices, so that there was a contractual termination.
What word is governed by pursuant in the 4th line? Is it not terminated in the 1st line?
Yes, it is, but
so the finding is it was terminated pursuant to the termination notices.
Yes, as I say, but his conclusion was it terminated, and the reason it terminated was because of the effect of the termination notices.
Yes. The declaration is that it's terminated pursuant to the termination notice.
Yes.
So all that has to go, doesn't it, if you're wrong on ground 1?
But just to be clear, as I said, we advanced 2 cases below as to why it had terminated. So we said we're entitled to a declaration of termination. The first base on which we seek it is because of the termination notices. But if we're wrong about that, we have a second case as well, which entitles us also to a declaration of termination, but because of the effect of the sales. The judge accepted our first case. He therefore didn't need to deal with our second case. We're now before this court. We say we're right on the first case, that the declaration should be upheld. If we're wrong on the first case, we say nonetheless the judge was right to make the declaration of termination for the second reason.
But that supposes he did make a general declaration of termination. That just isn't how paragraph 1 is phrased, is it?
Well, we're into form over substance here in my submission.
Well, maybe, but we're looking at whether you can bring yourself within the rubric of upholding an order that was made
On different
for
grounds.
different reasons.
Yes.
And if something says the lease was determined pursuant to termination notices, you're not upholding that order. If you want to say that ownership or the lease came to an end as a result of subsequent transfer of ownership to trustee owners.
Well, in my submission, this is a form over substance point, because what the relief we were seeking at trial was a declaration of termination of the leasing. As I say, we put forward two bases on which we were seeking that.
I understand that, but it's a question. Isn't that just simply a question of looking at the order and seeing whether what you're now trying to do,
but we're not,
is uphold that order?
No, but we're not appealing against this order. I mean, that's, I think, self-evident. We're not appealing against this order. What we're saying is this order is correct. He was right to make the order.
But you're saying this order is correct for the additional reason that the leases were terminated as a result of the
Yes.
transfer to the new owners and its registration.
And that's a respondent's notice point, because
That would be a respondent's notice point if all this said was the defendant's right to lease each of the aircraft was terminated.
Well, in my submission, I mean, this is now form over substance, which is the point.
Form matters because what you're asking us to do is uphold an order.
On the
And if the result of what you want to argue on your respondent's notice point is that this order will have to be amended to say something different, you're not asking us to uphold this order, are you?
Well, in my submission, that is, if I may say so, a very formalistic way of looking at this, because what you have here is what the judge has done is set out the declaration of the effect on the leasing, and then he's effectively then set out within paragraph 1 his reasoning then as to why it had terminated. So the order is in that declaration is effectively doing two things. It's setting out his conclusion on the consequence that the leasing had terminated, but also setting out his reason as to why it had terminated. And that, as I say, was the first case, which we advanced below. In our submission, if we're seeking to say, well, actually, his conclusion that the lease had terminated was right, but another way of upholding that is our second case, which was also advanced below, that's a respondent's notice point in our submission, and not a point where what we're seeking to do is appeal or vary the order. I mean, the other...
You want us to view paragraph 1 of the declaration as if it stopped at was terminated, and the remainder is verbiage or explanation. And if that were the case, then you'd be able to say we're upholding that single first sentence of declaration.
Yes.
Because it's true for another reason.
Exactly.
And it's just a question of whether that is correct, or whether in fact the declaration as it stands, or even if you take out all of the extra references to clauses, etc., whether in fact the declaration that was made is the defendant's right to lease each of the aircraft was terminated pursuant to the termination notices, which is the point.
Exactly, and in my submission, it is a form over substance point, because if you look at the substance of what's happening here, is we go to the judge and say, look, we think the leasing has terminated. We'd like a declaration to that effect. We appear before the judge. We make two arguments as to why that's right. He agrees with the first, doesn't need to deal with the second. He puts part of his reasoning as to why it has terminated pursuant to the first reason in the order. We're now in the appeal court. They say the judge got it wrong. We say the judge got it right. But even if he was wrong on the first basis, he was right on the second basis. And that is absolutely classic respondent's notice territory in my submission. I mean, the other way of looking at this is it's unreal to say that we are appealing against or seeking to vary paragraph 1. Our primary position is paragraph 1 is absolutely right. We don't have an appeal or variation. We only have a contingent argument to this court that if you're against us on that primary position, then we'd seek to uphold it on for the additional reasons. So I mean, that's why I showed you that subparagraph in Brace Yourself about form over substance. And in my submission, it does have to be looked at as a matter of substance and not of form. Now, if I can just show you...
So just before you leave the
Yes.
order, I suggested to Lord Wolfson that the order in paragraph 2,
Yes.
the declaration the defendant does not have the benefit of any rights or interest in the aircraft, would be an order that you were seeking to uphold on these alternative
Yes.
reasons. And therefore, they would properly form respondents' notice points in seeking to uphold that order.
Yes.
Do you want to adopt that?
Well, I adopt that, but I don't shrink from my submission in relation to paragraph 1, which is the primary way I'd put it. But I respectfully agree with your lordship and gratefully adopt that point. I mean, can I just show you also then the judgment? If you go to 319. And I think you've been provided with a copy of the flow chart which the judge used. And as you will have appreciated, he picked up the issues which he addressed in the judgment from the flow chart. And the respondent's notice goes to issue 9C. So this was one of the issues that was live before the judge. It was live on the pleadings. It was one of the issues in the flow chart. And you see 9C, did the sale of the CO aircraft extinguish any interest which VietJet as sublessee had held in the aircraft at common law, that's respondent's notice ground 1, or under the Cape Town regulation, that's respondent's notice ground 2. As he said, this question applies to both the NEO aircraft and the CO aircraft. However, it's not a question which arises given the answers to question 8 and 9. And that's where he's got to on the termination notices. Accordingly, I do not address it. Now, just to deal with one point, I think my learned friend, Lord Wolfson, said yesterday, I think it was, in response to a question, well, this is all new. Well, that's not right. It's not new. It was the subject of submissions to the judge. If necessary, we can give you the paragraph references in the closing submissions. It's only new in the sense it doesn't feature in the judgment because the judge took the view, well, he didn't need to address it, given where he'd got to on the effect of the termination notices. And again, in my submission, this is absolutely classic respondent's notice territory because we've gone to the judge on 2 bases. He's accepted our case on 1 basis. He hasn't felt the need, I'm not criticising the judge for this at all, he hasn't felt the need to deal with the 2nd basis, but we're entitled to come along on appeal, I suggest, without permission and say, well, if actually it turns out the judge was wrong on the 1st basis, nevertheless he was right on the 2nd basis. And that's essentially the point.
Looking at substance over form, does it matter whether you're within paragraph 1 or paragraph 2 of the order?
No.
One or other way?
Yes. Absolutely, yes. And to deal with some of the other, I think 2 other points were made. I mean, and this is to pick up my Lord Justice Popplewell's point being put to me earlier. It's right that the terms of the declaration would be different given the way it was framed. If we're declaration 1, I'm talking about. If we're right on the 2nd ground rather than the 1st ground, I mean, that's obviously right. But that's always going to be the case where you have a declaration which sets out the reasons for the grant of the declaration, and a respondent then seeks to uphold it on a different ground. And equally, it's correct, or it may be correct, that the sums which VietJet would be liable to pay would be different if the termination was on a different basis. But again, that's simply a consequence of the declaration being upheld on a different basis. So in our submission, there just isn't anything in this point that permission is required. We put in a respondent's notice. the respondent's notice makes the points very clearly. They've been addressed very clearly in our skeleton argument. They're not new because they were put below, so it's not one of those cases where we need permission to advance a point being put for the first time on appeal. So in our submission, absolutely nothing in that. And subject to the court, I would propose to address the substance of the response.
But just before you do that, Lord Wolfson's point that the quantum would be different. I don't think this order itself identifies what is to be the subject matter of the quantum hearing, but it's implicit in it, isn't it?
Yes.
That there is, in this order, that there is to be a further quantum hearing to decide what the quantum should be on the basis of these findings.
Yes.
And if you succeeded on your alternative grounds, then that would involve a different implicit quantum hearing order, wouldn't it?
A different outcome to the quantum.
Well, and if it's implicit in this, that there should be a further hearing of quantum arising out of the liability as here found, then you might be in some difficulty, mightn't you? Otherwise, you would be, you would actually be varying that implicit order as to how quantum was to be dealt with or calculated. Do you understand the point?
I do, but I'm not sure. I'm not sure whether the order for the further hearing is explicitly saying no,
because it had already been decided that there was going to be a liability hearing followed by a quantum hearing. But it might well be implicit in this order.
In my submission,
not
because
is to be conducted on the basis of these findings on liability.
Well, I mean, I think...
And if it were, then you would be varying this order, wouldn't you? Yes.
But I don't... I mean, I think my answer to it is that's not what it says. So,
right.
I mean, let's put it... obviously, the proceedings were bifurcated. So there's a second quantum stream. Liability was separated from quantum. But clearly, the quantum will take effect of whatever the outcome of the liability proceeding is, including any appeal. Yes, and I know the quantum hearing's taken place, as I said before the judge. But I don't quite see that's a bar to us why we need permission to appeal this order.
Well, if you're not seeking to vary the order itself, but only to uphold it, whether it's under 1 or 2, fine. And I understand your points on 1 and 2, saying under one or the other.
Yes.
Your respondent's notice points uphold those 2 aspects. But if this order should be treated as saying implicitly, and the quantum hearing shall determine quantum in accordance with this order, then you would be, wouldn't you?
Yes, I mean, I think...
Perhaps not. Perhaps. Forgive me. Perhaps,
I mean,
perhaps if all you're doing is upholding 2, then it wouldn't be.
And I think, I mean, so far as this order is concerned, so in other words, the one beginning at 58 of the core bundle.
Yeah.
But as far as I can see, it doesn't say anything about the quantum here.
No, I don't. That's why I put it to you on whether it's implicit or not.
In my submission, it isn't, and that's not part of this order. I mean, no doubt there's other orders which are provided for bifurcation of the proceedings into liability and quantum, but it's not part of this order.
Yeah. All right. Thank you.
So I mean, that's our point, and as I say, I mean, ultimately, it's not, in my respect, it's not a complex point. I mean, it's a commonplace situation where ultimately we put it on 2 bases to the judge. He's upheld it on 1. We come along to the appeal court saying if he was wrong about 1, well, he was right about the other. So, I mean, what I'm proposing then to do subject to the court telling me otherwise, is briefly address the respondent's notice grounds. You haven't had any written material from the respondents on the substance, nor any oral submissions from the respondents on the substance. It feels like, for whatever reason, they've pinned their colours to the mast of the permission point, which in my submission was not a safe mast to pin them to. But I will deal with the 2 points orally and give you the references in our written material. So the first is respondent's notice ground 1, and we deal with this in our skeleton argument at paragraphs 26 through to 34, which begins in the core bundle at page 192. The point in our submission is ultimately straightforward. What we say is that at the time of the sales to the trustee owners in January 2022, VietJet, as sublessee, had no right to use or possession of the aircraft. Now, so far as that's concerned, there is no dispute that as at January 2022, there were continuing events of default under the leases arising from VietJet's non-payment of rent. They were also long-standing defaults, just to make that point. If you go to 148 of the core bundle, within the judge's judgment, at paragraph 358, in 358, he helpfully, in a table, gives the length of default, length of time of default since the date of the length of default to the date of the termination notices. So that's October 2021. If you wind it forward to the time of the sales in January 2022, you can add another few months to that. So these are long-standing defaults that hadn't been remedied for a long time by the time you get to January 2022. And as a result of those defaults, VietJet had no right to use and possession under the terms of the subleases. And you get that if we go to the sublease, which we've been using, which is in the supplemental bundle. The lease itself begins at 542 and it's clause 6.4. Bear with me. Which is at page 595.
So this is 6.4.
That's right. So it's headed
Sublease.
exactly, and it's headed quiet enjoyment. But what is highly relevant about this is that the covenant of quiet enjoyment, quiet use, possession, enjoyment, is subject to the requirement that there be no event of default under either the sublease or the lease. So it follows that if there isn't a continuing event of default under the lease, as indeed there was, then that there is no right to quiet use, possession or enjoyment given to the sublessee, i.e. VietJet. Now, that is important because if you go back to our skeleton argument, back in the core bundle, and this is at divider 9, at page 194, footnote 12, by way of background, we explain that there is a controversy in the law where you have a lease of a chattel, whether a sale of the chattel brings the lease to an end. And that's a controversy which really falls into two groups proponents of different views depending on the question of whether a lease of a chattel is considered to create a proprietary interest in favour of the lessee. And some people say it does, and some people say it doesn't. And that hasn't been really resolved by the courts yet. And you can see both proponents of those views are very distinguished, and they both have articulate reasons. Now, that point happily doesn't arise in our case because of 6.4, because under the terms of this particular lease, because there was a continuing event of default, the sublessee didn't, at the time of the sales, have a right under the lease to use, possession or enjoyment of the property. So that whole debate, which would otherwise be a difficult point, doesn't arise in this case. And our position is that simply at the time of the sales to the trustee owners in January 2022, VietJet had no right to use and possession under the terms of the subleases. Whatever other rights it had in relation to the leasing were personal in nature and did not and could not bind the trustee owners. And the effect of the sales to the trustee owners was therefore to terminate the leasing, in that the terms of the lease and the subleases did not bind the trustee owners as the new owners of the assets. So, put another way, what rights VietJet had were contractual, personal in nature, and once title to the asset was transferred to the new owner, those personal contractual rights don't transfer over and don't bind the new owner. And that is essentially Respondent's notice ground one. The point we've dealt with in the skeleton argument, and this is simply for completeness, is to say none of that is affected by the judge's view that for the purposes of seeking relief against forfeiture, VietJet has a sufficient interest to seek relief against forfeiture, which, as you may recall, he found there was jurisdiction to grant that relief, but he declined to do so as a matter of discretion. And that's because for the purposes of relief from forfeiture, that interest is assessed prior to the occurrence of the event of default, whereas the sales took place after the event of default had occurred in January 2022, and indeed when they were continuing and had been long-standing for some period of time. So that essentially is Respondent's notice ground one.
Is this point also an answer to relief against forfeiture? What order? Suppose that the judge had decided that relief from forfeiture was appropriate. What then happens if you're right about this?
Well, relief against the relief against forfeiture was in relation to the effect of the termination notices. So what he was saying, how that arose, was in response to the argument that the termination notices had terminated the leases. I don't think forfeiture would be an answer to the contention that the interest of the sublessee had been lost by a sale, certainly in circumstances where relief hadn't been granted before the sales took place.
So this point would be of itself an answer to the relief against forfeiture?
It would, yes. It would if that had been carried through. Yes. So, and obviously the judge didn't need to decide it in that way, given he'd already not decided it. And it's quite clear, I think, when he's looking at relief against forfeiture, he's looking at that on the footing that the leases have terminated because of the termination notices. So the relief being sought is to effectively undo that forfeiture of the leases. So then, so that's in itself a complete answer as a Respondent's notice ground. The second ground is based on the Cape Town Convention. It's a similar point in substance, but it's just framed by reference to the provisions of the Convention rather than the common law. Now, we deal with this in the Annex A to our skeleton argument, which begins at page 211 of the core bundle. The starting point, I think, has to be the Cape Town regulations themselves, you will find those in the authorities bundle at page 48. The starting point is Regulation 4, which is on page 49. Now, you can see in Regulation 4 that defines the Cape Town Convention and also the Aircraft Protocol. The scheme can be a little unusual because the consequence of the way in which the legislation has been put in place is there may be 3 different sources of what is ultimately the same right, because you may find it in the regulations, in the convention itself, and also in the protocol. But the way the regulations work is effectively to define the Cape Town Convention and the Aircraft Protocol. They've set out the text of both the convention and the protocol in Schedules 1 and 2. But what they don't do, this is not a piece of legislation that says the Cape Town Convention and the Aircraft Protocol have effect as set out in the form of the schedule. It's rather the regulations that are the substantive law, and effectively they then cross-refer to particular provisions and parts of the convention and the protocol. So it's not a case where you can simply say, well, the convention and the protocol have been incorporated and implemented directly. So as a matter of English law, the foundation for the convention rights, if I can call it that, is to be found in the regulations themselves, at least as your first port of call. Now, if you go to Regulation 6.1, which is on page 53, 6.1 provides that the international interest provided for by Articles 2 to 7 of the Cape Town Convention is recognised in relation to aircraft objects. So this is an example where specific articles of the convention are referred to. Aircraft objects basically mean aircraft and helicopters. So it's defined as airframes, aircraft engines and helicopters. If you put an airframe and aircraft engines together, you get an aircraft. So you can regard aircraft objects as essentially meaning aircraft. And the international interest, and if you'll note the judge dealt with this in the judgment, paragraphs 24 to 25, is a form of sui generis interest created by the Cape Town Convention. It's an interest created by that. It's subject to registration, as we'll see in a moment. The consequences of that are that it has certain effects in terms of priority and the rights in which it confers on the holder of the interest. But the international interest is essentially a sui generis interest created by the convention itself. Now, just to go through, if you go to 54 of the page 54 of the authorities bundle, regulations 14 and 15 deal with registration of an international interest. And as you might expect, there's various formalities that have to be complied with. And then the key provision for present purposes is really on page 55, and it's regulation 16. So 16.1, a registered interest has priority over any other interest subsequently registered and over an unregistered interest. So a registered interest is simply an international interest that has been registered. So essentially, if you register it, then you get priority over anything that hasn't been registered and over anything that's registered subsequently. So not necessarily surprising as a matter of priority based on the registration regime. Sub 3 then deals with the situation where there's a sale of the aircraft. The buyer of an aircraft object under a registered sale acquires its interest in it subject to an interest previously registered. So if you're a buyer and you come along and buy an aircraft, again, perhaps not surprisingly, you take that subject to an international interest that's been registered. But then subparagraph 5 is the one we rely on. A buyer of an aircraft object under a registered sale or a registered prospective sale acquires its interest in that aircraft object free from an interest subsequently registered and from an unregistered interest, even if the buyer has actual knowledge of the unregistered interest. So it's a very clear-cut regime based essentially on registration. So even if as a buyer, even if you have actual notice of an unregistered interest, if it hasn't been registered and you complete the sale, you take free of that unregistered interest. And an unregistered interest is defined back in paragraph, so page 52. I mean, and it's essentially any form of right or interest that hasn't been registered, whether or not it's capable of being registered. So essentially it's a category that captures any right or interest that has not been registered. So I think we can probably just pick that up. And I should say for your note, I don't think we need to turn them up, but you will find corresponding provisions, as I mentioned, in both the convention and in the protocol itself. But as I say, the ones that matter in our submission legally are the regulations, and it's the extent they cross-refer into the convention and the protocol, you need to look at the protocol. So I'm not going to take time by taking you to the identical provisions, similar provisions that you find in the convention and the protocol itself. Now, just pausing there, our position is essentially a simple one. We say to the extent that VietJet had any interest in the aircraft at the time of the sales to the trustee owners, then these were unregistered interests. And that pursuant to Article 16, so pursuant to Regulation 16.5, the trustee owners acquired title free of such interests, irrespective of whether or not they had actual knowledge of them.
Were the leases capable of being registered? Can the lessee register an interest under the Cape Town Convention?
The lessee?
Yeah.
No, it couldn't. But that's why I showed you.
No, I understand.
Yes, I think that's right, because I think your lordship's absolutely right, because if you go to the definition of international interest, I think perhaps you get this from, yes, I think you maybe need to look in the...
held by a creditor.
Yeah, exactly. That's exactly the point. It has to be held by a creditor. Yes, it's page 71 of the authorities bundle. You actually have to get this from the convention itself.
I think page 51.
Oh, no, sorry, you're right. It's in page 51. Exactly, it's the same. But that, yes, international interest means an interest held by a creditor. So in our submission, it wouldn't have been capable of being registered, but obviously that, given the way unregistered interest is defined, that's not a point that helps VietJet. In fact, it's a point that helps us, because I don't think VietJet's ever contended it did register its own interest, but it quite clearly couldn't have done, given the way international interest is defined. Now, the argument that was put against us at trial, and I don't know whether it's repeated on appeal or not, is set out in paragraph 6 of Annex A. So if you go to the core bundle at 211, and we've set out in paragraph 6 what the argument was that was run by VietJet at trial. And it's, in our submission, somewhat contrived argument. It goes like this. They say that the interests of the lessors and sublessors were international interests which were registered. Next step is then to say that those interests of the lessors and sublessors were subject to the interest of VietJet as sublessee in relation to its right to possession and quiet enjoyment. The international interests of the lessors and the sublessors were registered, and the trustee owners, it said, acquired the aircraft subject to those interests. And then it said to follow from that because the lessors and sublessors' own interests were subject to VietJet's interest as lessee, then somehow the trustee owner also took subject to VietJet's interests. So essentially it's trying to piggyback on the lessor's interest, which was registered, and to say, well, look, the lessor's interest was registered. There's a sort of carve out to the lessor's interest, which is the lessee's interest. And therefore, we're able to take advantage of the fact that the lessor's interest was registered so that our own unregistered interest binds the trustee owner. So I mean, it's a derivative argument, a dog leg. I don't know how you might want to describe it. It's essentially trying to piggyback, as I say, on the interest of the lessor, which was an interest held as creditor, which was registered. Now, in our submission, that's wrong. Firstly, as we've already touched on, if you look at the interest of VietJet as sublessee, quite clearly that was not an international interest because it was not an interest held by it as a creditor. We've already looked at that in Authorities Bundle 51. And in our submission, absolutely clear that VietJet's interest as sublessee is not an international interest. And if that's right, it must, by definition, be an unregistered interest. And that, we submit, is a complete answer to the point, and VietJet can't get around that by trying to point to a different interest held by the lessor, which is an international interest because it's held by the lessor as creditor. The fact that the lessor has that interest doesn't mean that the lessee has an international interest at all. It's a complete non sequitur.
And so, in fact, only creditors' interests are protected here.
Yes.
That's it.
Basically. And as I say, it's a very...
Because lessees are put in the equivalent position of simply having contractual rights against a chattel, no proprietary interest, and therefore no protection in the event of a
sale.
Of a purchaser. I mean, is that broadly the scheme of it?
Basically. And it is, as you'll see, as I said, it's a very black and white regime, which is based very much on registration, as you'll have seen. It all turns on that. It all turns on you having an international interest that is in fact registered. And that's the basis on which this works. And ultimately, if you're not in the register, then you're vulnerable on a sale. I mean, no doubt you'll have your remedies against the seller, but not in relation to the buyer, so far as title to the aircraft is concerned. Now, the second point, so that first point is a complete answer. The second reason why it's a bad point anyway is that VietJet...
Sorry, if I understood Article 40 right, that any contracting state can add categories.
Can add to the categories.
Can add to the categories.
Yes.
So it would be up to a contracting state if they wanted to say lessees' rights come with it. I think they then become non-consensual.
That's right.
Registrable interests.
That's right. I mean, there has been no...
but there's nothing of that.
There's nothing of that nature in relation to the which is applicable in relation to the present case. So that first point is in our submission a complete answer. That point that we summarised in paragraph 6 of Annex A isn't a good point. I mean, the second reason why it's not a good point is the point I've already made in relation to the common law position, which is that VietJet's interest as sublessee is said to be its right to quiet possession and enjoyment, which of course is a right it had, but only so long as no event of default had occurred and was continuing. So for that reason also, it didn't in fact have the interest which it asserts at the time of the sales in January 2022. So it fails for that reason also. Now, what that means, just pausing there, what that means is we say Respondent's notice ground 2 works irrespective of whether the trustee owners took free of the title of the lessors or not. And you could just pause there and say, well, actually, you don't need to go on and address the further question of whether the trustee owners took subject to the title of the lessors, because actually VietJet just didn't have an international interest, even if the trustee owners did take subject to the interests of the lessors. But if it's necessary to go on and address that further question, we say actually the trustee owners took without not subject to the interests of the lessors and sublessors as well. And we address this in paragraph 12 of the annex, and I'll deal with this relatively quickly because we're now getting quite a long way down the batting order in terms of my answers as to why we're right ultimately on ground 1. But we deal with this in, as I say, really paragraph 11 at page 213 of the core bundle. And the position in relation to this is that each of the aircraft, as I think explained yesterday, was subject to a New York law mortgage. Those mortgages were registered in priority to all other international interests. And you get that recorded by the judge in the judgment at paragraph 23(1). And then if you go to the regulations at page 57, you have this provision in sub-rule 7 of rule 20. Ownership or any other interest of the chargeor passing on a sale under regulation 19(2)(b) or passing under subparagraph 2 or 3 is free from any other interest over which the chargee's security has priority under the provisions of regulation 16. So essentially what this is saying is where you have a sale which takes place by way of the enforcement of security, then the purchaser acquires title free of every interest over which the security itself has priority. So it's a particular provision dealing with a sale taking effect by way of security, and it's essentially saying, well, if the security itself has priority over everyone else, then the purchaser acquiring through the security has the same priority. Now, as I say, the mortgages here did have priority. That's an admitted, undisputable fact as per paragraph 23(1) of the judgment. And the ownership of the aircraft did pass pursuant to sales falling within the scope of regulation 20 sub 7. So far as the NEO aircraft are concerned, the sales fell within regulation 20 sub 2. And you can see 20 sub 2 says the chargee and all the interested persons may agree that ownership of or any other interest of the charger in any aircraft object covered by the security interest is to vest in the chargee in or towards the satisfaction of secured obligations. So essentially that's dealing with a sale, a consensual sale, where all the parties agree. And that was the position in relation to the NEO aircraft, because the NEO lessors agreed to the sale. It was a consensual sale to which the NEO lessors were parties, and you get that from the judgment I showed you earlier at judgment 58. So in the case of the NEOs, it was a consensual sale of effectively the chargeor, the NEO lessors were parties to the sale, and the consideration they got was the discharge of the obligations which they owed. So it was a consensual process, and in our submission, that falls quite squarely within Regulation 20 sub 2. So far as the CO aircraft are different, they weren't sold pursuant to a consensual sale. They were sold by way of public auction. And the question in relation to the CO aircraft is then whether they fall within Regulation 19 2B. And you see that at the top of page 57, and the chargee may exercise any one or more of the following remedies. It may sell or grant a lease of any such aircraft object. But the rub or the qualification to Regulation 19.2b is if you go to page 59 in Regulation 24.1, there's a qualification that if you have a remedy, you must exercise it in a commercially reasonable manner. So not an entirely surprising qualification to see. Now, the question then is really twofold. Were the CO aircraft sold in a commercially reasonable manner? And we submit that they were. I'm not going to go through the points orally, but we rely on the points made at paragraphs 31 to 37 of the annex. There was obviously a difficulty in the sense that at the time of the sales, the aircraft was still in Vietnam. But that was because VietJet had not given up possession, and it didn't do so until December 2022, notwithstanding that the termination notices directed it to do so. So clearly there was a difficulty in the sense that it wasn't possible to produce the aircraft to a prospective purchaser without them having to go to Vietnam and presumably without VietJet cooperating.
But these are all factual matters.
They are.
Which the judge, which were disputed, because as I understand it, VietJet said it was anything but a properly organised public sale, and in which the judge made no findings. So are we in a position to make findings on that?
Well, we've put forward our submissions as to why it was commercially reasonable. You've been met with silence on the other side, and in my submission, it's not open to a person facing a respondent's notice to come along on appeal and not deal with it, and then say, well, look, the appeal court isn't in a position to deal with it. I mean, they haven't. I don't know whether they dispute it on appeal. They haven't said anything. Literally nothing.
Haven't they said this can't be decided by us? It must be decided by the first instance judge. So that's their point. It is a question of fact which we can't resolve, therefore has to go back.
Well, I mean, what you have is our submission. We've put forward our submissions on this in the annex. I mean, if your lordship, unless you get to this stage of the analysis, which is, as I say, I mean, the only by this stage, the only reason you get here is if you've decided actually it's crucial to the analysis to decide that the trustee owners took free of the lessor's interests. And as I say, my primary submission is you don't in fact need to get there because they can't claim an interest through the lessors. If you're against me on that, this point doesn't apply to the NEO aircraft at all. Got a complete answer to that on a matter of law. If we get all the way down the decision chain and you think in relation to this point on the CO aircraft, because it's a factual point, would have to be remitted back. Well, I don't think I can press you further on that. I've made my submissions. I think my ultimate submission is you don't need to get there, actually, and it sort of cut off before you do. And indeed, the other point I'd make about this as to why the factual point doesn't even arise in relation to CO aircraft, even if you get this far, is that the requirement of commercial reasonableness isn't expressed to be a condition precedent to the exercise of the power of sale. It doesn't follow that if the sale hadn't been carried out in a commercially reasonable manner, it would be defective, as opposed to simply giving a remedy as a matter of accounting or damages against the person who carried out the sale. It doesn't say that at all. And in my submission, the better conclusion would be that even if there had been a breach of the commercially reasonableness requirement, it wouldn't invalidate the sale. It would just give rise to an accounting remedy as against the seller. So for that reason, also, it's cut off as a matter of law. And I should say, I was going to add this authority to the bundle, but just for your note, that analysis is consistent with the position under the financial collateral regulations, where the commercially reasonableness requirement doesn't invalidate the appropriation of collateral. It merely gives rise to an accounting remedy against the person carrying out the appropriation. So for all those reasons, we say ultimately we get there on Respondent's Notice ground 2. Perhaps if you'll just permit me to turn my back for one moment. I'm subject to any questions from the court, those who ask submissions. I think Mr. Peacock has found perhaps the case he was looking for earlier.
Thank you very much, Mr. Smith. I have a little note here which says Mr. Peacock, tax authorities for his proposition.
Yes. We have a short adjournment found a suitable authority that I confess I should have remembered but hadn't. There's a case called Lionel Simmons Properties. We'll send you a note with the details on which Lord Wilberforce in the House of Lords. He says in the context of a debate about trading or investment that it has to be one or the other, it can't be both. And that's been cited with approval in this court and in the House of Lords subsequently in the case of Ensign Tankers and in the Privy Council. So we will provide those references to you later this afternoon. But I didn't want you to walk away thinking that there was nothing to come. It is coming.
Thank you very much. Where are we?
My lady, my lords, what we propose to do in the time we have for replies to approach it in the same sort of order as we did in our original submissions, if that's helpful. So I'll start with ground 2, then I'll say a word about ground 1 and the respondent's notice. In response to a question from my Lord Justice Popplewell, my learned friend confirmed that his case is that financial institution bears the meaning given to it by Lord Justice Old in SR. He said that's exactly it. There isn't much more to it than that yesterday. There is a little more to it than that, we respectfully submit. But my learned friend really is putting all, or certainly the vast majority of his eggs, in the SR basket. And we do submit that SR is not the answer here, not least because it involved a different question. And if you ask a different question, you're likely to get a different answer. And a critical flaw we respectfully submit in what my learned friend submitted was that he ignores really that there are 3 different formulations in this contract, in this case, which contain the term, each of which contains the term financial institution. And as I say, they're different from each other. Clause 17.1, Clause 9.1a, and Clause 21.23b. And I'll come back to that. But to deal with SR head-on, and Lord Justice Ald's interpretation of the meaning of financial institution in that case, the learned friend said at one point that, quotes, it was common ground that FWC satisfied that definition, i.e. Lord Justice Ald's definition of financial institution, That's day 2, page 192. Now, just to be clear, that's a piece of forensic shorthand, let me say, from a learned friend, which I don't object to, I admire it, but we need to put it in context. The paragraph of the judgment my learned friend was referring to is 226, as I understand it. And when one actually looks at 226, the learned judge there records the position that if the only wording under consideration were that in 9.1, my understanding, the judge's understanding, is that VietJet wouldn't seek to quibble that FWC comes within the scope of financial institution language to be found there. In other words, if all you had in the contract was that clause and it just said bank or financial institution, then we wouldn't quibble with learned friend's contention that in those circumstances they could come, or perhaps even would come, with financial institution. Now, of course, but then we'd be talking about a very different contract. I mean, this is the point. In those circumstances, the main plank of my argument would have gone. I wouldn't be playing off or contrasting the broad formulation of the universe of potential assignees with consent against the narrower formulation in 9.1a and the other formulation in 21.23. Now, even then, it would be certainly strongly arguable that FWC wouldn't come within the definition of financial institution, certainly if you take into account Lord Justice Ricks's formulation in SR, but I'll come back to that. But just to be clear, that paragraph 226, the if line, i.e. the condition which the learned judge is positing, is absolutely critical because it deals with a very different situation. Now, I mean, on that, the passage from the Banking Encyclopedia, which the court was taken to, doesn't take matters any further, in my respectful submission. That paragraph is concerned with a different question. It's concerned with the question, to whom can assignments be made? And it emphasises the breadth of the universe of potential assignees in the normal case. And of course, that's really what SR was concerned with. The whole point about SR, my respectful submission, is that because loans are generally transferable, if we see in a loan that it is transferable, we shouldn't assume that the parties placed undue restrictions on the transferability of the loan by circumscribing or limiting the nature of potential assignee or transferee. But as the Banking Encyclopedia itself says, and if we pick it up in the summary of SR on page 3 in the second paragraph, the way they put it is this, learned editors: a financial institution does not have to be like a bank. It must be concerned with commercial finance and provide capital to financial markets. It must be a business entity that regularly makes purchases or invests in loan securities or other financial assets. Since it must be an institution, it must be an entity of a certain substance and not insubstantial. Now, what the learned editors seem to do there is to seem, so to speak, to have the best of both worlds. They want to have the best of Lord Justice Old and the best of Lord Justice Ricks, if I can put it respectfully, because it was Lord Justice Ricks who refers to a substance requirement, as the court has seen. Now, why do I refer to that? I refer to that because my learned friend wanted to say that Lord Justice Old's definition of financial institution is the established market meaning. Well, so far as the Banking Encyclopedia seems to indicate, with great respect, it isn't. And in my respectful submission, what SR is doing is identifying what those words, it's actually bank or other financial institution, would mean in a clause which is dealing with assignability of the loan when there's nothing else in the contract. That's what SR establishes. Now, we do respectfully submit that now that we have in this contract the broader wording added in by the Loan Market Association in what I call the second half, I think my Lord Justice Popplewell called the second half of the clause, that may well cover an SPV specifically established, that's the word used, to set up to hold the loan. And we respectfully agree that that would meet the position of FWC. It was established specifically for the purposes of this transaction, and therefore is very different to the position in SR. Although we criticised SR and the jibe about it being run from a flat in Belsize Park, which it was, in fact. I mean, that's actually where it was run from. It wasn't just a jibe for no reason. However, in SR, to be fair, Argo Fund was a hedge fund which had done other business. I mean, it was out there in the market buying loans, selling loans, doing all the rest of it. In our case, FWC was incorporated a couple of weeks before it bought this debt and was incorporated only for this transaction. And just to make that good, paragraph 5 of SR for the court's note sets out the history of Argo and what it had previously done. Now,
but by the time it purports to take the assignment, which is the first point in time that matters.
This FWC, my lord?
FWC?
Yes.
Yes. It is carrying out activity. It's not just in the established to do something in the future category, is it? So,
by definition,
so you may say, well, the activity that it was carrying out in this transaction was not substantial enough to meet the test. But we're not in the SPV set up to do something in the future. You emphasise the date of incorporation, but does that matter?
Well, I wonder whether, with respect, my lord's point proves too much, because the definition only ever bites when something happens, when you do something. In other words, the point my lord is putting to me will always be the case, and yet the definition, the second part of the definition, certainly talks about, as my lord pointed out, is in the second part of it, established for the purposes of. So if that language is going to have any meaning, it would appear to apply to a case where it's been established for the purpose of, and this is the first transaction. Perhaps even this is the second transaction, but certainly the first transaction. If the answer was, well, because they're doing this transaction, the date of establishment is no longer relevant, then one would ask rhetorically, why is establishment referred to in the first place? Because there's always going to be an action, because there's always going to be an assignment or a transfer, otherwise we wouldn't be having the discussion. Now, some points therefore on, so our essential submission is we're not obviously querying or questioning the decision in Argo, but one has to remember what Argo is deciding, why it was deciding it, and the language here is very different. Now, you've been shown, handed up an extract from the LMA investment grade facility agreement, and I'm afraid once one bit of agreements are handed up, other bits tend to be. So, with apologies, can I hand up another bit from this? Thank you. Thank you. And thank you. I think we provided these electronically as well. Now, I'm going to use the internal page numbering, if we may. We can see that clause. If we,
I'm sorry. This is
from the well, it's from the multi-currency term revolving facilities agreement LMA standard. As my learned friend says, there were lots of LMA.
It's a different version of an LMA thing.
It's the same one.
Okay.
It's the same one. It's just a different bit of it.
Okay. Yep.
Yeah, exactly. Now, on the bit that my learned friend handed to you, so you get that on my screen as well. We can see there that paragraph 26, clause 26 of the LMA agreement is almost identical to clause 17.1 of our loan agreement. Now, clause 17.1 adds a reference to rights and obligations, quotes, under the operative document, but I don't think anything turns on that. And one also has an identical definition of lender. The LMA definition of lender is at page 14 of the handout, which I've just handed up to the court. And lender is defined as any original lender, and then the court sees what we have. And we've got almost the same in ours. The difference is any other entity, and ours says other person, and we've touched on that. I would, however, point out to the court, pursuant to Lord Justice Popplewell's intervention on that, that person is actually defined in the Neo Loan Agreement at Supplemental Bundle 8, at page 234, as any individual firm, company, corporation, unincorporated association or body, etc., or other entity. So that is beautifully circuitous.
Well, on reflection, it struck me I was making a duff point because the LMA wording must mean what it means. And the parties have obviously adopted it for 17.2 in this contract. So that...
yeah, so 17.1.
17.1.
Yeah.
So,
Yeah.
so,
Yeah.
so we must look at entity without reference to any elision that might be in the new lender provision, but thank you for that.
Yes,
It was a bad point even on its own terms.
well, I was agreeing with my lord's answer. I wasn't by nodding agreeing with the duff point, just to be very clear. That's well above my pay grade. Now, as the court knows, under our loan agreements, 17.2 provides that consent of the borrower is not required, provided certain conditions are met, and that's where you get into the definition of qualifying lender. Now, under the LMA, it is different. Under the LMA, as we see in 26.2, the LMA standard provides that the consent of the company is required unless certain conditions are met. Now, one of those is that the assignment is to another lender or affiliate of any lender. But there's no requirement in that LMA provision that such a lender must be a qualifying lender in the terms that we have it here. Secondly, however, and perhaps a little confusingly, in the LMA standard, there is a reference to what's called a qualifying lender. In the extract I've handed up, it's in clause 15, which begins on internal page 65. You'll see that clause is tax gross up and indemnities. And it's all about whether you've got to make payments without a tax deduction unless required to by law. I won't crunch through the whole of that, given the time. But you'll see the definition of qualifying lender at the top of page 66. Now, the obvious point to make is that obviously qualifying lender here is a very different definition because it's doing a very different thing. Now, where does all of this take us? Where it takes us is, I'm afraid, I hope, back to my central submission, which is, at the end of the day, we really need to look at our contract and all of its clauses in its own terms. And the LMA will only take us so far, because once you dip into LMA land, if I can put it that way, the highways and byways of LMA land don't help, and they actually become misleading.
I'm sorry to be tiresome, but what does qualifying lender, is it referred to anywhere else in the LMA wording other than in the equivalent of our clause 9, their clause 15?
I think that the answer to that is no, but can we check that? Can we check that? It's certainly not referred to, and this is the central point I'm making, it's certainly not used in the assignments and transfers context.
Where does it come in where does it come in this clause?
I'm sorry? Where's it?
For what purpose is the definition adopted in
this
clause
clause?
15?
If one looks at page 68, my lord, 15.2 D1.
D1.
So, essentially, a borrower or obligor has to make payments without a tax deduction unless required to by law. And if a tax deduction is required, the borrower has to withhold the tax, pay it to the tax authority, and gross up the payment to the lender. So the lender receives the payment in full. But that gross up obligation only applies if, and this is where you get into 15.2D, etc., the lenders are, quotes, qualifying lenders. That's the context in which qualifying lenders is used in the LMA standard. But it doesn't help us in this case.
But in our situation, we had no grossing up, and
the main point I make is that in our situation, qualifying lenders is used in a completely different context to talk about who are the sort of people you can assign to without consent.
As well as being used in an equivalent context, because it all comes out of clause 9.
I accept that, absolutely, exactly.
I have your point.
Yeah. Now, the central point is that the draftsman didn't follow the LMA standard when it comes to the permitted assignees point, and that's really in one sentence, my submission. Now, therefore, we respectfully submit given that the draftsman has taken the time and trouble to have a narrower universe for qualifying lender than he does for the universe of lenders to whom you can assign with consent, that has to be given some proper meaning. Now, in that regard, we get to learn the friend's answer, one of his answers to this point, which is that the draftsman tries to obliterate the conceptual target. We had the customary references to Arbuthnottenfegen, etc. Now, the problem with that is that on the learned friend's case, it appears that the draftsman, so to speak, empties his magazine into clause 17.1 and tries to obliterate it, the target, but holds his fire, at least somewhat, in clauses 9.1a and 21.23. The only other explanation we had from a learned friend as to why 9.1 refers only to bank or financial institution rather than incorporating the rest of the language in 17.1 was that it was a slip. That's page 17 of the transcript. It's just a slip and it's fallen out of the drafting. I mean, that is with respect to say, an incredible submission, not least because we've been looking at Little Roman 3 in 17.1, but in Little Roman 1, in the same clause, we have bank, financial institution, or company organised or incorporated under the laws of Japan. So it's not credible that having included that definition in Little 1, the draftsman slipped up in 3 by omitting the trust fund or other entity wording that was included in 17.1. And Little 3 is also relevant because we submit that it contemplates that a lender might be a company which is licensed to carry on banking or lending business, and yet is still not a financial institution, otherwise you wouldn't need to add in the word company. And that indicates that trust fund or other entity wording is intended to include some companies which are not financial institutions. I'm The other point I should just pick up is a point Malone Friend made this morning in his skeleton at paragraph 45 to the effect that it would be odd and impractical if you had to derive the meaning of the formulation in 2123 for the appointment of a replacement security trustee from the wording of another bit of the agreement, i.e. the provisions dealing with assignment at clause 17. With respect, we really don't accept that and we don't really even follow it. Where terms aren't defined in a contract, it's commonly the case that you have to look at other clauses in which those terms are found in order to work out what they mean generally in the contract. There's nothing remarkable or impractical about that. And when 2123 talks about trust corporation, bank or financial institution, any lawyer, we respectfully submit, would, when asking the question, well, what does financial institution mean, would immediately look at other clauses in the contract where that phrase is used, including clause 17. So those are responsive submissions to ground 2. And we do say, in summary, that SR is not the answer to the question because it was asking a different question. On ground 1, I'm just concerned not to trespass on Mr. Thompson's time. Ground 1, my lady, my lords, mortgages. The thrust of Malone Friend's submission was that you should treat the lessor security assignments as equitable mortgages, and I think that was in response to a question from my Lord Justice Zacaroli. Now, if we follow through the consequences of that as easily as we can do in short reply submissions, and while I accept there are some dicta to the contrary, and maybe even a case or two to the contrary, in my respectful submission, the orthodox position is that an equitable mortgagee doesn't have a right to go into possession as a legal incident of his security. And that's certainly the way it's set out, we submit in the textbooks. So what you would expect to see in our case is a contractual power to go into possession. And you do find that. You find that in clause 7. For example, in 712, a right to call in the property. At 714, a right to bring proceedings. At 716, a right to appoint a receiver. Now, all of those rights are conditioned by the need to have an enforcement event. I mean, so much is common ground. But my learned friend's approach, and I take this from day 2, page 166, his approach is that the key feature, he said, of the powers in 7.1 is that the exercise of those powers destroys the assignal's equity of redemption in the property. Now, while that may be true for some of the powers in clause 7.1, it's not true for others. Calling in the property, bringing proceedings, appointing the receiver, they don't, in my submission, destroy the equity of redemption. So that can't be the reason, it can't be the explanation as to why they're qualified by the enforcement event requirement. In my learned friend's case, you end up in the position where to take possession of, use or sell the assigned property, you need an enforcement event, but the pure exercise of a right, such as terminating the leasing, can be done by the security trustee at any time. And we submit respectfully that that's anomalous. And the better view, the better approach is to regard terminating the leasing of the aircraft as part of calling in the assigned property under 712 and 715, and you can only do that if there's been an enforcement event. To pick up another couple of short points on ground 1, I can take this one very shortly. I thought originally it was actually a jury point that was being made, but it turned out to be a point of substance, that we negotiated with Natixis, it was said, and they're the security trustee. Oh well, it seemed to be the submission. You must have realised that they could actually do things. Otherwise, why were you talking with them? Well, they weren't just the security trustee, they were the facility agent as well. And you're obviously going to knock on the door of the facility agent. Indeed, from paragraph 30 to 32 of the judgment, the learned judge notes that we wrote to Natixis, quotes, as lender for the NEO aircraft. That wasn't a matter for the security trustee. And indeed, it's the facility agent, rather than the security trustee, who has the active involvement. If I can just, without reading it out, clause 21.2a of the document, supplemental bundle 8291, I won't read out the whole thing, but starts off, the security trustee's duties under the operative documents are solely mechanical and administrative in nature, and goes on in B to say that he's got to act in accordance with instructions given by the facility agent. The last couple of points I have on ground 1, before I say a very quick word about the respondent's notice, is a couple of points on the Cape Town Convention. First, we respectfully submit it would be somewhat bizarre to rely on the convention to terminate, as opposed to relying on the contractual termination clauses, because the contractual termination clauses give rise to the obligations to pay liquidated sums, to the point I was making in the context of the respondent's notice as well. But a termination under the convention doesn't. So the question of how the convention termination rights work is a matter of entire theoretical interest, given the way the case against us has been pursued. Nobody here relied on convention termination rights. The convention was used to obtain possession of the aircraft, not to obtain termination rights. The second point is that we don't accept respectfully that the parties cannot, by contract, change or restrict the default provision provided for in the convention. We rely on Regulation 9.2. I'll just give the court the reference, Authorities Bundle, tab 4, page 53, which allows the party to derogate from or vary the effect of Regulation 21. That is the provision relied on by my learned friend as giving the lessor the right to terminate and take possession or control the aircraft. The reference there is day 2, page 173, line 23. To say a very quick word about the respondent's notice points, we do hang our hat on what we said about whether this is a proper respondent's notice. We are not ignoring the reality of what a respondent is trying to do. Indeed, we are relying on the reality of what this respondent is trying to do. By changing the basis of the termination, that has a critical effect upon the relief which they're entitled to, which is a point I made earlier. And it's not just, as the court will appreciate, it's not just that the learned judge envisaged that there would be a quantum trial on that basis. There has been a quantum trial on that basis. Indeed, on Monday morning, I thought the learned friend's position was that we shouldn't be allowed to present this appeal because we hadn't paid monies which would are only due because they won a quantum trial on the basis of this form of termination. So it's a bit odd that on Thursday afternoon, the point against me apparently is, well, none of that really matters. It certainly mattered, so far as we understood it, on Monday morning. And the fact is they are, with respect, trying to get a different order from this court. There was a whole argument, let me just put it this way, before the learned judge as to a very late change in the case of Fitzwalter. And you see that recorded, I think it's at paragraph 93, I think, of the judgment. We said that all of this doesn't arise unless various antecedent questions are decided against us, and it gives rise to various issues under New York law, which the judge below was simply not equipped to deal with. And we do maintain that stance in the alternative, so to speak, before this court, that if this court is against me, that these points should be open to my learned friend at all. They are simply not points which, with respect, could be properly and fairly decided by this court. Just want to check that I've made the other points, which I have. Yes, I think I have. Oh, sorry. I'm told I misspoke earlier, for which I apologise. At page 156 of today's transcript, when I referred to bank, financial institution or company, I said this was 17.1. I obviously meant 9.1, but I think the court appreciated that. Unless there are any further questions, I was going to hand over to Mr Thompson to say something about ground 3.
Thank you.
I'm grateful.
My lady, I yield to no one in my respect for Mr Peacock, whose reputation and experience in this field is unrivalled and certainly much superior to mine. But at some points his submissions seem to be not much more than take my word for it. Mr Thompson is wrong, this is heresy, and you'd be overturning too much if you made a decision. In fact, a lot of his submission just sounded so reasonable as to brook no reply at all. But in fact, I have 2 short points of reply where I insist I am right and he is wrong, notwithstanding his submissions. 3 points which I'm going to submit to you. In fact, what Mr Peacock is doing is a conjuring trick, a sleight of hand where he's answering the wrong question. And although logically he may well be right, it doesn't actually assist you. And 2.5 points on the authorities. The first 2 short points are very short indeed. I said to your ladyship and your lordships that Lord Briggs had said in Fowler that there was it was appropriate to look at the OECD commentaries, but he didn't suggest you could look at any OECD materials. Mr Peacock told me that, or told you, that Lord Reid had said you could look at anything you like, and I was wrong about that. With respect, Lord Reid didn't say anything on the topic. The reference is tab 16, page 418. I'm not going to take you to it. And Lord Briggs did say, as I submitted, you can look at the commentaries. That's tab 20, page 527. My respectful submission, you can see full well the logic of Lord Briggs's judgment and dicta on that point. Commentaries obviously have a superior status. They might be given greater prominence because of the thought that's gone into them. Some category of documents might well be considered to be a better aid for interpretation than others in an institution like the OECD. The second point I make is similar. I had submitted to your ladyship and your lordships that the Japanese tax form was not something you should be used as an aid to interpretation. I based that on dicta of Lady Justice Falk in the GE finance case. And my friend didn't demur from the point of law, so I'm lucky I'm right about that. However, he said we weren't actually, his client wasn't actually relying on the guidance as a mode of interpretation. But in fact, that's exactly what the judge did with respect. In paragraph 256, he said this guidance, and that was the word he used to describe the wording on the form, is consistent with a distinction in English law. That is, using it as an aid to interpretation, that is not permitted. The 3 points where my old friend Mr Peacock, I suggest, drew your attention to the wrong things are these. The first one is, my old friend said there are 3 categories. He set out for you 3 categories which he implied incorporated the universe of possible things in this arena. They're not the universe, let me say that. The first one, he said, was you might be not making investments, not making or managing investments, you might be trading. That's certainly a possibility. He said you might be doing these things for others. That's certainly a possibility. And then he said you might be making or managing investments as a bank. But of course, that misses out the 4th category if you're going to exhaust the possibilities under Article 22.5, which is that you're making and managing investments for your own account, but you're not a bank. So the very important category into which we say FWC falls was one that Mr Peacock simply didn't tell you existed. He created 3 categories into which he's quite evidently FWC couldn't fall, but also it failed logically to exhaust the possible types of businesses captured or identified in Article 22.5. The second sleight of hand from Mr Peacock, let me not call it a sleight of hand, that's probably unfair. He conceded a point which wasn't clearly or squarely made before today, as far as I can recollect, but which probably has always been the case, that the fund, that is to say the 100% owner of FWC, if you remember the chart, was a hedge fund that was carrying out investment activity, was his words. That's page 48, line 24. And if your ladyship and lordships recall, what he was doing was he's describing a hedge fund generally. He said, well, you have funds and you have managers. And he said FWC is neither a fund nor a manager. But he made it very clear that the fund, unsurprisingly, is a fund. That is to say, the company that we call a fund, the immediate parent to FWC, is a fund. Now, that is not something that's been fairly and squarely said before Mr Peacock said it. But if that is right, and it's unsurprising that it is right, it doesn't help my own friend at all. Because, I'm not sure that we focused on this provision sufficiently before, but if you look back at Article 22.5 on page 28 of the authorities bundle, you can see there's a very important deeming provision in this regard. And it's unsurprising there's a deeming provision given the object and purpose of this article. The deeming provision at C makes it clear that a connected party is deemed to be doing the same business as the original party. So let me read C. In determining whether a person is carrying on business in a contracting state under subparagraph A of this paragraph, and then there are 2 limbs to this, and I'll call them 1 and 2. 1, the business conducted by a partnership in which that person is a partner, and 2, the business conducted by persons connected to such persons, then it carries on, shall be deemed to be conducted by such person. A person should be connected to another one if one possesses at least 50% of the beneficial interest in the other, or in the case of company shares representing at least 50% of the voting power of the company, or another person possesses directly or indirectly at least 50% of the beneficial interest in each person. And in each case, a person should be considered to be connected to another if on the basis of the facts and circumstances one has control of the other, or both are under the control of the same person. So if your sister company, or your parent company, or your child company is doing the business, that counts. Now, you can't take this for the entire universe of a group, but you can take it if it's more than a 50% beneficial interest. And it's obvious why you'd have that provision. You'd have that provision to make sure that you didn't simply create £1 subsidiary companies, which then carefully fell outside the treaty shopping provision. If you consider again the object and purpose of this provision, and indeed the treaty generally, it is to make sure that there isn't treaty shopping. And one way you make sure there isn't treaty shopping is to make sure that people don't artificially create corporate structures where the business is conducted by a subsidiary or indeed by a parent, and then the other company is the one on which focus is brought by 22.5a. So if that is right, then that's a complete answer to this. And it's unsurprising it's a complete answer because, again, the purpose and object of this treaty is to look at the substance of what is happening, not the form. If it just looked at the corporate entities, you'd miss the reality. The third sleight of hand, maybe I should change the name for this, the logical inconsistency in my learned friend's submissions was, well, no, this was a sleight of hand, was simply to ignore again the wording of 22.5a. He simply didn't engage with the submissions that I made on the brackets in 22.5a. Can I just remind the court why I think this is important? If you look at the brackets, it says, and just going to deal with the exception, other than the business of making or managing investments for the resident's own account, unless the business is banking, insurance, or securities business. Well, the business is a reference back to the business of making or managing investments for your own account, quite evidently. So it must be the case that whoever drafted this article was considering that it was a logical possibility or practical possibility that there might be a business of making and managing investments, which was banking, insurance, and securities business. So again, my learned friend misses the whole problem with his client's position on this article, because he didn't address the question of whether this article is designed to capture people who do banking and insurance and securities business but aren't banks, insurance companies or security dealers. It falls out of the brackets, the parentheses in here, that is a category of business which this article is concerned with. It must be. And he simply didn't address that question. Let me call this business a quasi-bank. A quasi-bank might be making or managing investments for its own account, but not be a bank, insurance company, or securities dealer. That is precisely the entity which is not allowed to take the benefit of the treaty under this article. That's what it's trying to get at. Now, again, my learned friend completely ignored the possibility that such an entity might exist, whereas, in fact, the whole point of the parentheses here is to capture that sort of entity. 2 points on the authorities, 2.5 points, I say. The first is Cook. That's tab. Wrong bundle. Just switch. 10. Tab 10 of the authorities bundle. This is the case about the housing company. Going to take you to some other points in this judgment, which doesn't, in my respectful submissions, support what my learned friend says. If you look at the first 5 lines of the head note, or maybe there's the third to the 5th line, it says around C, under its rules and objects of the society, were to provide housing to those in need at rents they could afford, and Rule 4 prohibited it from trading. This was the problem in the case. It was prohibited from trading. Now, if you pick it up first, please, at 193, and we'll look at E first. This is, just to orientate your ladyship and your lordship, this is the decision of the Special Commissioner, Dr. Avery Jones, and in this he's recording counsel, Mr. Prosser's submission there. And at 12, he first alludes to the definition of investment company from the 1988 Act, and it means a company whose business consists wholly or mainly in the making, and it's only making, of investments, not managing, and the principal part of whose income is derived therefrom. And then you can see Mr. Prosser's submissions in paragraph 13. And this is, if you pick it up at G, after 19 years, a society can expect to have a substantial surplus, some 30 million pounds per annum before tax, for making further investments in housing for rent. There are factual differences between the society and other perhaps more normal investment companies, such as the prohibition on distribution of profits, registration under the IPSA Act 1965 requiring benefit to the community, and preventing trading from profits. But they did not change the nature of the activity so much that the society could not be considered an investment company. So here is a company which is precluded from trading. It's different from a normal investment company, but is it nevertheless an investment company, even though it's not allowed to trade? That's what causes problems. Now, you would have thought, if my submissions were heretical, this wouldn't be a very difficult case to decide, because it couldn't trade, it had some money, it's got to be investment. My own friend says the dichotomy is hard and built into the law. Why was there all this argument? In fact, that isn't what happened, because if you see, firstly, Mr. Prosser's submissions were accepted, and then Mr. Justice Lightman, when he came to consider the point, made it clear that he thought this might have been a problem, but it actually wasn't. So look at 198H. Perhaps I'm going to pick it up at D first. D contains a judicial definition of the word investment, not hugely controversial, I respectfully submit. Investment means the laying out of monies in anticipation of a profitable capital or income return. So you can buy it to get a turn on capital, or you can buy it to get income. That doesn't matter, unsurprisingly. At H, this is Mr. Justice Lightman, I have been somewhat exercised by Rule 4, the prohibition on trade, and the prohibition therein contained on trading at a profit. But I've concluded that Rule 4 is consistent with the view that society is to be an investment company. He's troubled by it. Why would he be troubled with it if Mr. Peacock was right? He would rather be heartened by it. He would think, well, that's great. If it's not allowed to trade, it must be an investment company. But of course, if you think about this housing company, that distinction makes no sense. For it requires the company, Mr. Justice Lightman continues, to purchase property for long-term retention only and prohibits society from carrying on the business of dealing in or trading properties. Rule 4 cannot sensibly be read as prohibiting the achievement of the society's objects, the provision of affordable housing in such a manner as enables a profit to be made with which to further the society's objects, and accordingly in no way precluded the society intending, as they have throughout, to obtain a profitable return on the purchase and management of the portfolio. So they were making investments, they were making a profit on it. The fact that they weren't allowed to trade troubled the judge briefly, but in the end he thought didn't matter. The other case I want to look at is nuclear electric, which I think is slightly earlier, tab 9 in the bundle. In this case...
Sorry, before we do that,
yes.
have we got Rule 4 set out anywhere in this judgment? You took us to the head.
The bar on... yes, I think it's... No, maybe it's not. I was rather just assuming it from the description. Is it set out? 196H, Mr. Robertson reminds, yes, but it simply says the society shall not trade for profit. Nuclear electric, if I can go to that very briefly, page 183, tab 9 of the bundle. The facts of this case, as I think Mr. Peacock explained, are set out at 185B. Effectively, nuclear electric invested £520 million of its trading receipts in the National Loan Fund to make provision for its back-end costs. So it was designed to create an income to pay for its costs in disposing of nuclear material after there was spent. It was that income which was the subject of the appeal. Could you pick up at F what Lord Justice Millett, as he then said, about what he said about this, that income from investments held by a trader is prima facie investment income, but it may in certain circumstances be brought into account as a trading receipt. Whether it may or may not do so depends on the nature, depends on the nature of the trade. What the authority shows that the nature of the trade must be such that it can fairly be said that the making and holding of investments at interest is an integral part of the trade. Well, I might be heretical, but I doubt Lord Millett can ever be accused of that. He is quite clear there that it is possible for income from investments to be investment income, but it might not be. Of course, the key question in this case was whether the investment income, the £93 million, could be offset against the trading losses. What Nuclear Electric was trying to do was say, well, yes, we've made income from our investments, but can we set that off against our trading? And the actual ratio of the case, which is at page 189 of the bundle, 535 of the report, starts at B from Lord Jauncey, with whom I think all the other law lords agree. Whether income from investments held by a business is trading income must ultimately depend on the nature of the business and the purpose for which the fund is held. So it's not a given, it depends on the type of business. At one end of the scale are insurance companies and banks, part of whose business is the making and holding of investments to meet current liabilities. Now, this again was part of Learned Friend's sleight of hand, because he said, oh yes, but actually, what banks do is two totally different things, like holding companies. Holding companies might do two separate activities. Don't confuse the two, as effectively his submission. But that isn't what the law says. The law says banks are trading businesses which can make investments and derive income. And if you go back to the primary rule of interpretation in the treaty, we are supposed to be giving words their ordinary meaning. And if we slice up and say, well, banking business, it's doing two separate businesses, it makes no sense. Actually, banking business includes at least trading and making investments. And in some instances, there might be a debate for tax purposes whether a particular sum of money should be treated as a trading receipt or an investment receipt. But that all depends. Lord Justice Millett and Lord Jauncey explained that in those passages. My half comment on the authorities was that I heard what my learned friend said a half an hour ago about the Lord Wilberforce case. I don't have it in front of me. My learned friend, Mr Robertson, diligently looked it up and identified that it seems to be about how you treat an asset, which is quite a long way away from how you treat a business. In fact, quite a lot of my learned friend's cases talk about how to treat an income. And don't forget, we're talking about a business under Article 22A. Can I reserve the right, if I may, to respond on any points of law on that Lord Wilberforce authority that Mr Assumption has sprung on us by a very short note, if I may? I don't want, if the court doesn't want it, I won't. But if it is, I'm told that what I'm saying is heresy, and there's a case that I haven't seen that proves what I'm saying is heresy, I wouldn't mind the opportunity to rebut that.
Well, I can quite see that you should have that opportunity, but I would be grateful if you kept that as short as possible.
Of course.
And no more than 2 pages.
I understood. That would be more than sufficient, I hope.
And I can't remember what day it is almost.
Nor can I.
We've been together for so long, I think it's Thursday. But if you could do that by close of play tomorrow, I think.
Yes.
Thank you very much.
Certainly. I don't know if Mr Peacock is going to produce any of the other hundreds of authorities or simply rely on that, but if he does have others, perhaps I could.
I think he mentioned 3.
Today. He did, didn't he?
I think he's going to provide 3 to us.
Well, perhaps if he could provide them by the close
And so your note
today.
might be a little longer.
I'm sorry?
And so your note might be a little longer.
Yes.
But not much.
No, and my time will be fixed, so I hope Mr Peacock is speedy with his provision of his authorities.
Well, of course, Mr Thompson, if you don't get them, you can't respond to them.
I don't want to get them at 4 tomorrow. My lady, ground 5, for everyone's relief, not least mine, I'm going to say extremely little about ground 5. Just, I'm going to say, I think, 2 points on the merits and 1 point on jurisdiction. On the merits, my learned friend Mr Lissack, when pressed, was trying to identify the factual findings upon which the learned judge made his findings at 377. I won't take you back to that. And he identified, I think, three. One he said was the passing of material from VietJet to other entities. The second was the timing, and the third was the interest that VietJet would have had in supporting the injunction which was made in the Vietnamese courts. If this case was actually an instance of a judge making factual findings, then in my respectful submission, they were unjustified because there wasn't any evidence. You can look through the rest of the judgment. You will not find any specific factual findings upon which the conclusions were made, except arguably those 3 points. So it all then hinges on...
I think he had a fourth, which was the correspondence.
I'm going to come to the correspondence. I'll come to the correspondence, my lord, yes. I haven't forgotten that. But in the first instance, I think he relied on those three. I'll just mention those three briefly. The passing material, in my respectful submission, takes us nowhere. It might or may not have been that material ended up in somebody's hands. That doesn't really assist in the answer about whether some persons were doing an act on behalf of VietJet.
Why not? If the material was VietJet's material, and somebody, perhaps inferentially, the judge thought Madame Tao provided it to Silver Star for the purposes of Silver Star's action, would that not be activity which was attributable to VietJet?
But my lord, implicit in your question was it was provided for that purpose by that person to the other, and that wasn't really... The judge didn't go into the depth of that answer because he effectively said there was passing material from VietJet, but he didn't identify that it was for that purpose, and there was no basis for him to say it was for that purpose. But it was... This only works, obviously, if it's coupled with other things. That wouldn't work on its own. I think everyone accepts that. It has to be the coincidence of the findings of fact that lead to the judge's ultimate conclusion that would make it work. And as I said when I was on my feet before, actually there was no case run as a matter of fact. There was some sort of conspiracy, and this was all being done with people passing documents out the back door in order that this happened. What the judge's findings are findings of law. He's saying it is implicit from this, that and the other that this is to be attributed to VietJet, and that's the error with respect. But the second, just to unpick the second and third points of alleged fact, the extraordinary timing point, I already made submissions on it before, it's not extraordinary. It's exactly what you would expect one party to do if they were coming into or bringing new proceedings and wanted to retain the benefit of an injunction which was about to be discharged because there was a claimant who was about to leave the proceedings. If you were coming in as a second claimant, and you knew the first claimant was about to leave and the injunction would leave with that claimant, you would want to ensure, if you wanted the benefit of the injunction, that there was no gap, temporal gap, between the discharge of injunction 1 and the creation of injunction 2. It's not extraordinary at all.
I think that's what you said before.
It is. I'm sorry. I don't think I said this point before, I hope I didn't. On the third point, it was said, well, it's the interest of VietJet. I probably did say this, actually, now I think about it. The interest of VietJet to obtain the injunction, I think, as my Lord Justice Popplewell put to Mr Lissack, it might well have been in the interest of a shareholder also. So the fact that it was in the interest of VietJet, which I don't submit it was, I submit it wasn't, doesn't answer the question why it wouldn't also have been in the interest of the shareholder. On the correspondence point, my Lord, if you look at the judgment itself on this point, paragraphs 377. If you pick it up, page 152 of the bundle, I've shown you ad nauseam the paragraphs which I complain about. Paragraph 380, the judge turns to the correspondence. And he is changing topic. I make no complaint about 380 onwards. This brings me to the correspondence which I propose to address only briefly. This is correspondence with certain regulatory and governmental bodies in Vietnam on the status of the aircraft following the consent order. whatever the position in relation to the correspondence in the earlier period from April to August 2023, later correspondence, which was only disclosed by VietJet on the first day of the trial after the abandonment of its claim that the correspondence was subject to state secrecy, shows very clearly that VietJet has sought to interfere with the efforts to export the aircraft. He then goes on to deal with letters, you can see, dating from August 23 onwards. He is not talking about what he calls the earlier period, the correspondence between April and August 2023. There is a temporal gap between what he says about the proceedings in paragraphs 369 and 379, the paragraphs about which I'm making complaint, and his comments about the correspondence. It's clear from his structure of his judgment, from the logic of what he's saying, and the time periods we're talking about, that he does not rely on the correspondence as part of his conclusion in 377 and 378. Furthermore, there is absolutely no suggestion in the judgment, and never has been any suggestion even by the claimants, that the correspondence came from anyone other than VietJet. There's no suggestion that Madame Tao or Dr. Fong had been involved in the correspondence. In fact, I did a search on their names and they don't appear after paragraph 377 at all. There's no reference to them. So the complaints are fairly and squarely contained in and predicated upon what the judge says about the facts and the law between 369 and 379. Correspondence wasn't part of his thinking. Finally, on the question of jurisdiction, I tentatively tread into the topic and suggest we start with the skeleton argument that was lodged on behalf of the appellant for this appeal. You've already looked at it briefly, but can I just remind the court what we said about the reason we could bring this appeal under ground 5, which is at page, it's mainly contained in the footnote 14 at page 41 of the bundle. So you can see at footnote 14, VietJet recognised that the appeals are normally brought against orders, and that's the reference to the Supreme Court Act section, which I mentioned earlier in answer to Lord Justice Popplewell's question, rather than specific findings and judgments. A finding may, however, be appealed where it's necessary to avoid a breach of Article 6, and to deny VietJet an appeal would infringe Article 6 because VietJet might be prejudiced in the contempt proceedings by a finding it could not challenge. I'm not going to say any more about that. You have my submissions on that. That is as far as I go on it. On Read W, I just want to take you to 2 paragraphs, and I want to explain to you how it is that in my submission you can and ought to expand this jurisdiction, what I say is marginally. It's tab 17 of the authorities bundle, and I referred during my own friend's submissions, I interrupted rudely to point to paragraph 46 at page 436 of the bundle, which is the reference to section 16 of the Senior Courts Act that refers to the Court of Appeal's jurisdiction to hear and determine appeals from judgments or orders. That's the word. What the learned Lord Justice McFarlane did in this case was refer to the other sources of jurisdiction in the County Courts Act and the Matrimonial and Family Proceedings Act, and picked up at 49 that there are various different words that are used, different provisions use different language to describe the things that can be appealed. Now, there's then a reference you can see to the company Noga case in 2003, and it's a useful case on this point because what happens in this decision is that counsel suggests to the Court of Appeal that they are not barred from making the sort of order that they're proposing, the appellants are proposing in this case, by virtue of the Noga case. but it's important to understand what was said in NOGA in that context. If you pick it up at 438D, there's an extract from the judgment of NOGA. Lord Justice Waller says in Read B, which is a case about, again, care proceedings, is a good decision, good example of a decision on preliminary issues of fact. Furthermore, the case having been adjourned and the facts making a difference as to what might flow from the adjournment, the facts in Mr Pollock's word were pregnant with legal consequences. If, however, in that case the court had gone on to make a decision in relation to the legal consequences which one party would not seek to challenge, in my view, that party would not be entitled simply to appeal the findings because it does not have the reasons for the decision in his or her favour. So you've got a decision that's in your favour, you can't appeal individual findings. That's not our case, obviously. It is in this context, it is in that context that it might be appropriate for a court of first instance to consider whether some declaration should be granted to provide a judgment or order or determination which might be the subject of an appeal. If, for example, the findings of fact might be relevant to some other proceedings, and Mr Pollock accepted this, it might be appropriate to make a declaration so as to enable a party to challenge those findings and not find him or herself prejudiced by them. The findings will still be pregnant with legal consequences. It's to go beyond the scope of this judgment to consider precisely what circumstances might allow for the granting of a declaration where findings of fact might affect other proceedings. Now, actually what happened in this case was that the Court of Appeal didn't consider that either a bar or particularly useful for their determination, so the argument was put to one side. But in my respectful submission, building on what Lord Justice Waller said, and given the thrust of what's said by Lord Justice McFarlane, it is still appropriate for this court to consider whether there might be something, to use slightly antiquated language now, that's pregnant with legal consequences. And if it were the case simply that what VietJet failed to do to give you jurisdiction was to ask the learned judge to make a formal declaration in the terms of paragraph 377, then that is, to borrow my learned friend's phrase, putting form above substance. And indeed, you can see at paragraph 118 that Lord Justice McFarlane was very glad not to be able to have to use that contrived vehicle. At H, he says, after saying he doesn't have to hold the NOGA approach as engaged, he says halfway down that paragraph, it's also not necessary to use the rather contrived vehicle of the judge's refusal to grant a declaration in the terms of the adverse findings in order in some way to generate an order or judgment that can be the subject of an appeal. So I accept that the judge wasn't requested to make such a judgment, but the point being made by the judge is that would be contrived. The Court of Appeal says it would be contrived. So for those reasons, I suggest that what the judge said, even though it wasn't encapsulated within a declaration, is susceptible to appeal for the reasons that I have given. Unless I can assist the court further, those are my submissions in reply.
Thank you.
My lady, I was simply going to say that on ground 4, I can't think of anything new to say. Therefore, I can't and indeed won't say anything. And I think we're out of time anyway.
I was going to say, I think you were out of time.
Exactly.
But don't force yourself.
Exactly. But obviously, sorry. I'm just going on this side of the court. We're very grateful to the court for giving us, giving us the extra time that we've had during the course of the hearing.
Thank you. Mr.
The
Lysaght?
risk of burning through the residual goodwill this court has shown for the last many days. Can I just make one correction, please, that may or may not be important? A learned friend told you that there is no suggestion that Madame Tao or Dr. Huang have been involved in the correspondence. That's not correct. The letters referred to in the judge's judgment, paragraphs 381, 383, 384 and 385 were signed by Dr. Huang. Thank you very much.
I'm sorry. Firstly, they're not before the court. And secondly, when a director signs on behalf of a company, it's the company's letter, not the director's letter. I'm grateful.
Thank you, everyone. Thank you very, very much for your detailed and very helpful submissions in this very difficult case. Thank you to everybody who has not been on their feet, but no doubt has done an enormous amount of work this week and before, both rows. As you will all be very well aware, well, first of all, we're going to not give judgment right now. And as you'll be very, very well aware, the way in which matters are dealt with here is that we will circulate our judgments as soon as we can for you to comment on small errors in the way of typos and grammar, but not re-arguments. Thank you. That draft will go out to those people whose emails have been provided. We take the embargo very seriously. If you want to widen that circle, please ask rather than do it in order to avoid difficulties. As you also very well know, all of you, consequential matters are dealt with on paper, and we hope that having seen the drafts, you'll be able to agree. If you can't, very, very short written submissions, please, and it will be dealt with, as I say, on paper. Thank you again for your submissions. I'm sorry, I forgot to say thank you also